Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 33 in the list of AOR leading cases, which is the case of Pramati Educational and Cultural Trust versus Union of India and others. Now, we will just go into a little history. We will look at case number 18 and 19 that we have discussed in the AOR leading cases list, which is PA Inamdar and TMA Pai Foundation. Now, in both the cases, it was held that the state cannot exercise a lot of power on private unaided institutions, right? Now, to overcome this judgment or to counterattack this judgment, Parliament enacted Article 15, Clause 5 by way of 93rd Constitutional Amendment Act. And it its validity was also challenged in the case of Ashok Kumar Thakur versus Union of India and therefore was upheld also. Now, in Pramati Educational Trust, the main question that lies here is on Article 15, Clause 5 and Article 21A. 21A is being inserted by the 86th Amendment Act. 15 Clause 5 is inserted by the 93rd Amendment Act. The petitioners herein are contending that it goes against the idea of right of carrying on profession, one's trade, one's business, which is incorporated in Article 19(1)(g). And therefore, to the extent these two amendment violates the basic structure doctrine, as they are also violative of equality, wherein state is imposing certain restrictions on admission criteria by way of Right to Education Act in these private institutions. Okay. Now, because private institutions do not form a part of state, and therefore the petitioners also are contending that such kind of practice stands discriminatory against them in the light of Article 15 Clause 5 as well as Article 21 Clause 21A. So court herein is looking at also the provision of Article 30 Article 30 Clause 1. It is also being said that if Article 21A abrogates the rights under Article 19(1)(g) and Article 30 Clause 1, it can be held ultra vires the Constitution. Okay, and right to so basically what is happening by way of 86th Amendment Act, Article 21A gets inserted, and in fulfillment of the purpose of Article 21A, the state enacts the law which is Right to Education Act in order to facilitate right of children to free and compulsory education, which is the goal of Article 21A. Now, herein, what is happening that petitioners are contending it that because it goes against their right of practicing their own profession, right? Their guarantees under Article 19 Clause 1, and it is holding that such practice is not facilitating equality and violating Article 19(1)(g) and 30 Clause 1, because there will be some kind of financial and administrative burden on in unaided institutions, which undermines their autonomy and their own right to manage their institutions. So therefore, because 86th Amendment, which is bringing 21A and also bringing Right to Education Act in the further facilitation, it is violating the basic structure doctrine as it compromises the constitutional freedom of these educational unaided private educational institutes. Whereas the Union of India is contending that Article 21A is guaranteeing nothing but fundamental right of education for children in the age bracket of 6 to 14 years, and minority institutions can enjoy the protection under Article 30 Clause 1, but private unaided non-minority schools do not enjoy absolute autonomy because 15 Clause 5 is upheld, and therefore they can be easily regulated. Now, court herein is answering the first question, that number one, Article 15 Clause 5 does not stand unconstitutional, as Ashok Kumar Thakur also upheld it as an enabling provision. Now, when you are allowing some kind of quota, state sponsored quota for the kids, not state sponsored, state guaranteed quota for the kids to be admitted in the private educational institute, it is not a violation of equality, but rather it is a facilitation of equality. The goal is to meet that all the children should get free and compulsory education under Article 21A as well as under the Right to Education Act. and it is also falling in the state's directive for promoting welfare and economic justice as well. Now court herein is also saying that article 21A is not violative neither of article 191G nor of article 30 clause 1, because minority institutions are left untouched in the scope of right to education act. Court is also stressing that article 21A, when added in the constitution of India, it is saying that state by any manner can make a law and manage for the education, free and compulsory education. So in that light, if the state is enacting a right to education act and it is directing private institutes, private unaided institutes to have an education quota for the children from disadvantageous group, it is nothing but facilitation of justice, and it is also a facet of you know equality, because we have studied that where there is a reasonable classification, law can be made like that. So here in court is protecting the right of education of the children coming from disadvantageous group, and therefore it is reasonably regulating the freedom under 191G as it is provided under 19 clause 6 as well. Therefore the court is upholding the validity of 15 clause 5, saying that no, it doesn't violate basic structure doctrine. Also upholding the right to education act, article 21A also is being upheld in this judgment, and therefore court is saying that we respect the autonomy of the private unaided institutes under article 191G. But article 191G also is required to be read harmoniously with the right to education act as well as article 21A. So right to education act and article 21A are not violative of any constitutional freedoms, but rather they have to read in harmonization. So the restriction imposed is reasonable. Right to education act is valid. It does not violate article 191G with respect to private unaided non-minority organizations, and RTE act does not apply to minority institution as it has been made very clear in its scope. So therefore constitutional amendment 93rd as well as 86, both of the constitutional amendments are valid. The reforms brought by them stands valid, and therefore they are not contradicting with the basic structure doctrine. So this is it, which was held in the case of TMA 5, which was held in the case of Pramati Education and Cultural Trust versus Union of India. I hope the discussion was useful. Thank you, everyone. Please stay tuned with Legal Darshan. Thank you, everyone. Stay tuned. Keep watching, keep liking, keep subscribing to Legal Darshan.